You have a U.S. protector. He has power over a U.S. trustee and a foreign trustee. The low profiler, is it a foreign trust? Is it a domestic trust? If there is a U.S. trustee and a U.S. protector, it is a U.S. trust. If the foreign trustee fires the U.S. trustee, now the trust is foreign. Even though the trust is under the law of the Cook Islands, it's a U.S. trust. But it is exempt from 3520 and 3520A. It is a U.S. trust under foreign law. If the horizon is clear, there's no litigation. The domestic trustee is the managing trustee. He does everything. The only thing he has to do is he should keep the foreign trustee informed, but he has all the power. When the horizon gets cloudy, the foreign trustee, which is simply the custodial trustee. Why? Because the bank account is offshore. He has custody of it, but the U.S. trustee has control. At that point, the horizon is cloudy, there's a threat. The foreign trustee now has the power to fire the domestic trustee. And we don't have to worry about the protector saying, no, you can't, because the protector is under duress, and nobody has to listen to anybody under duress. That's how we draft. If we use the Cook Islands, we are under the 1984 Cook Island Act with amendments. Look at Section 13D. Foreign judgments are not enforceable. They exclude foreign law. Isn't foreign law the Cook Island law? No, it's not. It's the U.S. law. We're looking from the point of view of the Cook Islands. They do not recognize U.S. law. They do recognize community property. Those of you who live in community property states, you transfer assets in as community property. It stays as community property. As far as the trustee is concerned, please read 19F. It tells you what the custodian trustee powers are. The custodial trustee, remember, the custodian trustee is the foreign trustee. The managing trustee is the U.S. This 19F. Trust property shall be held by the foreign, so they can't freeze it by somehow trying to touch the U.S. trustee. But the management of the trust property and all powers remain, because we want the court and control test, they remain in the managing trustee as if there was no custodian trustee. He's there, but he has no power. All the power is basically in the U.S. The function of the custodian trustee shall be to perform such acts as the managing trustee, the U.S. trustee, declares in writing. So, of the court and control test. He can defend it as a domestic trust because it is a domestic trust. On the other hand, if he thinks it's not wise to defend as a domestic trust, he can have it as a foreign trust. We just don't have the court and control test. It's a foreign. He has his choice how he wants to defend that trust. And if you're ever asked the question, do you have a foreign trust? Not according to the IRS, it's domestic. It's defense counsel's decision. It's not my decision. I set it up. It's his decision. He is now preparing for court. How does he want to defend the structure?